So my name is Julie Reid. I'm here as the practice management rep for the LMC. The LMC has been approached by a number of people in our constituency for the training need for an update on the deprivation of liberties and the lasting power of attorneys, but hopefully mostly key how we can adopt those and some practical tips in practice of how we can make that and support ourselves to do that. So Capsticks and LMC have kindly joined forces, and thank you Amy and Nadine for joining us today, and you guys are going to walk us through this very complex sort of topic. So over to you guys.
Thank you, Julie. So I'm Amy Holden. I'm an associate in the clinical advisory team at Capsticks, and my colleague Nadine is a senior solicitor in the same team. We're going to talk you through, as you've heard, all things related to LPAs, and we're going to touch on the deprivation of liberty as well. As you probably can all see, this is a recorded session, so you will be provided with a copy of the notes and the recording afterwards, should you wish to see them. And we will be doing a Q&A session at the end, should anybody have any questions. Due to time limits, we'd ask if you can keep your questions to the end, that would be great. The session is going to run for 2 hours, and we will do an initial presentation, and then we will have some more interaction towards the end, because we will be doing a case study. So we'll be asking you to consider some scenarios and give us the answers, and let's see if you can get them right. So first of all, we'll have a look at what we're covering. So if we can just look at the agenda for the day. So we're going to be looking at what an LPA is and the different types of LPA, how to create an LPA, the role of the certificate provider, how to spot when an LPA is valid, legal responsibilities of an attorney and whether that's jointly and or severally, attorney disputes, identifying and reporting concerns, when the Court of Protection would become involved, and then we're going to have a look at deprivations of liberty and who that really applies to. And then, as I said, we'll be moving on to that case study and the questions. So I'll hand over to Nadine now, who's going to talk us through what an LPA is. Thank you.
Thank you, Amy. Sorry, technical issues to start with before we even start today. So as Amy says, I'm a senior solicitor in the same team as Amy, and we work very closely. And lasting power of attorneys is something that we come across quite a lot in our day-to-day work. So we're going to have a look at lasting powers of attorney first, and what a lasting power of attorney is. Now, I'm sure you're probably all aware of it, but let's go back to basics. It's always a good place to start. And as we say, a lasting power of attorney is a way of an individual giving someone, the attorney, the legal authority to make decisions on their behalf if they lose the mental capacity to do so in the future, or if they no longer want to make decisions for themselves. And there are 2 types of lasting power of attorneys, and I'm going to call them LPAs because otherwise we'll spend half of this presentation just me saying lasting power of attorney. So there are 2 types of LPAs: LPAs for financial decisions and LPAs for health and welfare decisions. And to be quite honest, in both mine and Amy's roles, we mostly see queries in relation to LPAs for health and welfare, but we are going to touch on both of these today just because there are 2 types, so it's important that you know both. So if we move on to LPA for financial decisions, looking at those first, it gives the attorney the authority to make decisions about the donor's property and money. This can be day-to-day decisions, such as paying a bill, or more complex financial decisions, such as selling the donor's properties or shares. And as you can see on the slide at the second bullet point, we have highlighted some of the things that might be considered as part of an LPA for financial decisions. So as it says, buying and selling property, paying the mortgage, investing money, and then, as we say, simple day-to-day things, paying bills. An LPA for financial decisions are slightly different in respect of the capacity point to LPAs for health and welfare, because an LPA for financial decisions can be used whilst an individual still has capacity, or they can say that they only want it to come into force if they lose capacity. So there is the choice there in respect of financial LPAs. If you're setting up an LPA for financial decisions, it is possible to restrict the type of decisions that an attorney can make, or they can say that it lets them make all decisions on behalf of the individual. The attorney as well must keep accounts, and they must make sure that their money is kept separate from any decision making or any money that's spent on behalf of the donor. And the individual can ask for regular details of how much is spent, how much money they have, and ask them to provide basic accounting information. Moving on to, I suppose, what we might say is more familiar territory, an LPA for health and welfare decisions. As we've said in the second bullet point again, it generally make decisions about things such as where an individual should live, medical care, what they should eat, who they should have contact with, what kind of social activities they could take part in, and they can also give special permission for the attorney to make decisions about life-saving treatment, and it has to be specified in respect of life-saving treatment. We generally see LPAs for health and welfare decisions kind of come into our desk where there's been a dispute, and we are going to come into that in a lot more detail within this presentation. But LPAs for health and welfare are really kind of one of the issues that we see quite regularly, just because it gives that authority to somebody else to act on their behalf when they lose capacity, and trying to work out what is in somebody's best interests. And as that first bullet point has said, and really this is the most important point, that an LPA for health and welfare can only be used once an individual has lost mental capacity. So as we've touched on, to create an LPA, a person must be over the age of 18, and they must have the mental capacity to decide to make an LPA. So at the time of making the LPA, the individual must have the mental capacity to do so. And the person who the LPA is set up for, the individual, is always known as the donor. So as we've set out on this slide, it is quite clear how to make an LPA. So first of all, they have to choose an attorney. They can have more than one, but they must be over the age of 18, and they must have mental capacity. And we are going to touch on the types of LPAs and how individuals can act under an LPA in a little bit more detail later on in this presentation. But when there's more than one individual acting in accordance with an LPA, it can become quite complex for the reasons that we'll set out. You must be able to fill in the forms, obviously. Legal process will have forms that need to be filled in. The LPA must be signed by a certificate provider. We're going to come on to that in the next slide.
Yeah, because it's go do it as well.
Could I just ask everyone just to pop themselves on mute? I think we've just got a couple of people who've joined us. That'd be brilliant, thank you. So as I was saying, the LPA must be signed by a certificate provider, and we'll come on to that in a second. And then finally, it must be registered with the Office of Public Guardians. And this can take up to 10 weeks. There is, as you probably expect, a fee to pay, unless they're eligible for a reduction or an exemption. You do not need to live in the UK or be a British citizen to be an attorney. So that's always an interesting point that comes up. And I know both Amy and I have dealt with queries in the past in respect of that. The donor, the LPA must be registered, as we've said on the slides, and it can't be used during the registration process. So it is always important to kind of get these things in order as soon as possible. And I think that's really one of the most important things that I would always highlight from a practical perspective. We see a few LPAs that come across our desk that haven't been registered. So somebody thinks that they have an LPA in place, but until it's registered with the OPG, it can't really be used. So it is just important to make sure that all of the relevant steps have been completed. And we're going to come on to this in a little while. So as I said, you do need, the LPA must be signed by a certificate provider. So we have just popped on this slide just in respect of certificate providers. So as part of the LPA, the donor is required to have a certificate provided by someone who has known them well for over 2 years. So that's the knowledge-based certificate provider, or someone professional, skill-based, who can make judgments about their mental capacity at the time of making the LPA. And in terms of skill-based, it's sort of the usual people that you would probably expect. So a registered healthcare professional, a solicitor or a barrister, a registered social worker, or an independent mental capacity advocate. Somebody not on the above list can show what their relevant professional skills and expertise in determining mental capacity in order to be considered a skills-based certificate provider. And skills-based providers are entitled to charge a fee for providing the certificate. The certificate provider must ensure that the person who wishes to make an LPA is mentally capable of making that LPA, and there is no pressure on them to make one. And this is really important because it comes down to what people think they should be doing. So if you have got an elderly individual that thinks that they should be making an LPA, it's really important to kind of test that and make sure that A, they've got the mental capacity to do so, and secondly, that there's no undue pressure in order to make that LPA. And as we've said on this last slide, the donor must understand and be able to retain the necessary information in order to be deemed mentally capable within the guidelines of the Mental Capacity Act. And we are going to come back to the Mental Capacity Act, and I'm sure you probably all deal with it on a day-to-day basis, but as lawyers, we always go back to the Mental Capacity Act because it is such a building block of all of this sort of area of law. There are some people who can't be considered a certificate provider. And to be honest, they're probably the people that you would expect. So if you're a member of the donor's family or one of the attorney's family, and that's really to make sure that there's no undue influence, and there is that level of separation between making the LPA and the individuals that may be impacted by it. If you're a business partner or employed in the same firm as the donor, or an attorney in any LPA or old enduring power of attorney made by the same donor, or the owner, director, manager, or an employee of a care home in which the donor or family member lives. As we've set out on that bottom bullet point, there'll be no need for a certificate provider if, when the donor is making their LPA, they do not nominate anyone to be notified when registration of the LPA within the Public Guardianship Office occurs. Then a second separate certificate provider will also be required. Their role will be the same as the original certificate provider and the same restrictions apply. I don't really want to spend much more time than that on certificate providers, but it is important that we kind of highlighted it to you that it might be something that is considered or you may come across in part of dealing with LPAs. So one of the most important things in respect of LPA is this issue of capacity. And as I said, I do want to just touch up base and talk about the Mental Capacity Act because it is so important. And I'm sure that you're probably all aware of this, but as we say on this slide, there is always a presumption of capacity unless proved to the contrary. And that presumption applies over the age of 16. All practical steps to help make the decision. They may have capacity even if it's considered an unwise decision. And this is something, again, that we get drawn into quite often, that an individual wants to make an unwise decision. And really, when we ask the question, well, have they got capacity? And the answer to that is yes. Well, then that is their decision. If they want to make an unwise decision, then that is their decision. Just because it's an unwise decision doesn't mean that they don't have capacity to make that decision. A decision on behalf of someone who lacks capacity must be made in the person's best interests. And so it's really that balance of risks and benefits and whether the pros outweigh the cons of a decision and what the individual thinks is in their best interest. And it's also important to think that can a purpose or treatment or the decision that needs to be made, can it be achieved in a less restrictive way? So they're really the principles that underpin the Mental Capacity Act. But as I say, and I'm sure it's probably aware to you because it's in bold and underlined, that first bullet point is the one that's the most important one. So moving on to the two-stage test of the Mental Capacity Act. First of all, under section 2, a person lacks capacity if at the material time he is unable to make a decision for himself in relation to the matter because of, and again, the most important bit underlined, impairment of or disturbance in the functioning of the mind or brain. So that's the first part of the test. And then the second part of the test is the subsequent inability to make that decision. So they're unable to make a decision if they're unable to understand the information relevant to the decision, retain that information, use or weigh that information as part of the process of making the decision, and then finally communicate the decision. So as you will all be aware, it's all of those 4 bullet points that you need to consider as part of a capacity assessment. So as we've said, if it comes out at that capacity assessment that actually they have capacity, then they have autonomy to make their own treatment decisions, whether or not that it is an unwise decision. They have capacity, they can make that decision. They must be given sufficient information to make the decision. So this is about how many of the risks of particular treatment or how much information you give somebody to make a decision, and it will really depend on each individual person. Some people want all of the information, some people only want a little bit of an information. And it's about making sure that you know the person to an extent that you can determine how much information they should be given. And finally, this bottom bullet point, and I hope that this already happens, but we do see it occasionally, documenting capacity assessments is so important, making sure that you have a record of that, and also any discussions that you may have with the individual, again, documented. We see quite a lot that actually somebody may have done a capacity assessment and as part of that had a discussion with the individual. The capacity assessment document gets filled out, but the actual discussion with the patient doesn't get anywhere. And so there may be really important information in that discussion that doesn't factor into the capacity assessment document. So it's just about thinking and making sure that both of those are covered in any of the notes that are taken. So if at the end of the capacity assessment it comes out that an adult is lacking capacity, then as we've set out on this slide, there is a legal duty to treat in the patient's best interests. Section 4 of the Mental Capacity Act sets out the best interest checklist. And in particular, you must consider all relevant circumstances. And in particular, firstly, whether the patient may regain capacity, and if so, when. So if the individual is likely to be able to regain capacity, can the decision wait until that person has regained capacity? And then as far as reasonably practicable, you need to consider the past and present wishes and feelings of the individual, beliefs and values likely to influence decisions, consider the views of named persons, carers, individuals with lasting powers of attorney about what would be in the patient's best interests, and involve the patient wherever possible. So this really then ties back into LPAs. So the individuals with an LPA, so the attorneys under the LPA, should always be acting in a patient's best interest. So if you have an individual that lacks capacity and a decision needs to be made, and an individual has an LPA, for example, for health and welfare, and can make the decision, they should still be acting in the patient's best interest. Just because they've got an LPA does not mean that they can't act in a patient's best interest. That must always be at the heart of it. And then again, at the bottom of this slide, documentation. And I think we've popped an exclamation mark on the end of it, because again, it is so important. Any decisions that are reached, any discussions, especially with attorneys under an LPA, should always be documented, because there's your evidence that you've had those discussions and you've thought about best interests in terms of the patient. So finally, before I hand back to Amy to look at other particular topics in this matter, how do you know if an LPA is valid? So as I've said, it must be valid in order for it to be applicable. And this slide really sets it out in kind of simple terms. So to be legally valid, the LPA must be registered with the Office of Public Guardians before use. When shown an LPA, you should check whether the LPA is registered by checking the document for the OPG markings, calling the OPG, or searching the OPG's register. It's really easy now to check whether or not an LPA is valid and whether it's been registered, and it will come out in very simple language about whether or not it has been registered, so it's quite easy. If there is an urgent check, or you need an urgent check of a LPA, then there is a way of doing this now, and we've set it out. So you complete the application form, you quote urgent OPG 100 search in the subject line, and you'll receive an email confirming the information that you need, so that it is possible to get it quite quickly. And it is really important that you check that an LPA is valid before you rely on an LPA, because if it's not valid, as we've said, if it's not registered, then it's not valid. So just pulling up on the screen, and hopefully that is able to be seen, but that's really an example of a valid LPA, and you can see that it's been registered, it has the stamp on it, it's got the date of when it was registered, and it has the reference number as well. So that's on the form, and then also if you see an online version, it will very clearly say now that it's been registered on X date as well, so you know that it's legally valid. So that's really a bit of a whistle-stop tour of kind of the basics of LPAs, and I'm going to hand over to Amy now, who's going to discuss a few more topics in detail.
Thank you, Nadine. So this next slide is really just something to keep in your back pocket should you ever need it. So it sets out what the Office of Public Guardian is responsible for, which is registering LPAs, keeping a record of them and monitoring the use of them. And as you can see, there's some very handy links there which show you how to report any concerns, email address and telephone number, how to check if an LPA is being registered and search the register, and also look for valid examples should you need any help or assistance. So now we're going to have a look at the different ways an attorney can be appointed. So this slide really just defines what jointly and severally means. So jointly appointed attorneys means that all attorneys need to agree or give consent before an action is carried out under the LPA. Jointly and severally means that they can act together or on their own, and this can often be helpful if somebody wishes to take less of a role. For example, you've got 3 siblings, but one isn't really bothered. It just happens to be that mum's put all 3 down. Or it can also mean that sometimes things can be acted upon more quickly. But it is worth mentioning that it's really important to check the whole LPA document, because it may be that the donor has said that she wants some responsibilities to be joint and several and some just joint, or it may be that she says that she doesn't want them to have he or she have any responsibility over certain aspects of the affairs. So certainly worth checking. So now we'll move on to look at the specific responsibilities of an attorney. So as you can see, an attorney must act in the best interests of the donor, act within the limits or the remit of the LPA, and also, and important to note, help the donor to make decisions where possible. So an LPA doesn't give somebody an unlimited right to have authority all over their decisions, and if you can include the donor in that decision-making process, then that should be encouraged. Also, it's worth noting that if an attorney isn't acting properly, they could face criminal charges and also be ordered to compensate for losses incurred. And the most obvious example springs to mind is fraud, and depending on the value, the length of time that the abuse is going on, then it could be serious criminal charges, given the fact that it's a position of trust that's been abused due to the donor's vulnerability. But if you want more detailed information about lasting powers of attorney responsibilities, then this is available in the Mental Capacity Act Code of Practice, which will set out in detail exactly what they should and shouldn't do. So we'll now turn to look at the restrictions on an attorney. So on this slide, we can see an LPA may only authorise an attorney to act if the donor lacks mental capacity to make the decision. And as Nadine has already stressed, this restriction automatically applies to any health and welfare LPA. So for health and welfare LPAs as well, you can only make a decision regarding life-sustaining treatment if it specifically says so in the LPA, and that's often misunderstood. An LPA can also include further restrictions about gifts as well. So that's important to try and have a look at, especially if you think that there may be any odd behaviour going on from an attorney. And if you are only authorised to act if the donor lacks mental capacity, you need to check whether or not the donor has capacity on a decision by decision basis. And that would mean, can they make decisions which are smaller or more manageable compared to more complex decisions about where they should reside or their financial position. And then an attorney should start from the assumption that the donor is capable, and again look for ways to help the donor to make decisions rather than just taking control. So if we now turn to some more practical points for attorneys, and we'll just skim over these just because in terms of your information, it's just something for you to be aware of. So if you're acting under a property and finances LPA, then you must keep the finances separate to your own. So you must also keep accurate accounts to demonstrate what you have done if you've been making trips to the bank on behalf of the donor. You also need to make a decision, and let's say that the decision is particularly difficult, then you can seek advice, whether that be legal advice or some other support, but you cannot delegate your decision-making powers, and so the decision ultimately lies with you. And if you feel that the decision actually doesn't fit within the remit of the LPA, then there is the option of applying to the Court of Protection, and that may be if you need to consider making a large gift with regards to inheritance planning, then that's perhaps a little step beyond what the LPA envisaged, then you would need to go to court. So we'll have a look now at some red flags, and we've split them into health and financial. So we'll deal with financial first. And very straightforward, and perhaps some of you are familiar with these red flags, having seen them from from experience. So not keeping money separate between the attorney and the donor, the attorney is particularly secretive about the finances, the attorney is in financial difficulty themselves, there are loan or credit card applications made in the donor's name, high risk investments being undertaken or considered. There may be excessive gifts made to relatives, which wouldn't necessarily be the case should the donor have had capacity, and failure to pay donors' expenses or a general lack of money available to the donor. Let's say, for example, the donor's in a care home, needs to have a chiropody appointment or a hair appointment, and there isn't that money available. And also moving donor into care without anybody else's involvement may be one as well. So looking at health flags as well, refusing prescribed medication. So it may be that there's been a prescription for a medication and the attorney is just not pursuing that, or certainly not going to get it for the donor, not acting in the best interest of the donor in general. It may be that the attorney acts too quickly to get the donor moved into a home without consulting relatives, or if the donor is at home, there's clear signs of struggle or neglect there, and maybe a reluctance to engage with professionals. So if you do have any concerns or these red flags do sound familiar, then obviously you can report the concerns, and we'll just have another revisit at how you do that practically. So when you are reporting a concern, include in your report the donor's details to identify them fully, the date you first noticed the concern, any evidence that you have to support the concern, and that there may be some examples that we've just discussed, what you know of the donor's mental capacity and any capacity reports that you have access to, and your contact details as well. And once that report is prepared and sent to the OPG, they will then investigate this and see if they've got legal authority to take this further. And I refer you back to the resource page in order to do that. There are also other ways to report concerns, which we will look at the next slide. And that is, you can also contact Job Centre Plus for any concerns about benefits. Local adult social services would be able to assist if you have concerns about safeguarding. And ultimately the CQC as well would be able to assist if you had concerns about somebody living within a care home. Now we'll move on to what the OPG can do once you've raised a concern. So the OPG, we've mentioned that they may be able to embark on an investigation. So they can look at the actions of an attorney, and they can actually direct an official of the court to visit the attorney to investigate concerns further. The OPG has the power to remove attorneys if they feel that there's sufficient evidence, and in some cases they would apply to the Court of Protection themselves and cancel an LPA and or take action against the attorney. And we'll move on to the next slide now, which focuses on disagreement with the, and sorry, there's a typo on this slide. It should say disagreement with the decision of an attorney of an LPA for health and welfare rather than a donee. So if you were in disagreement, the starting point is to first go back to best interests and what you think is in the best interest of the donee. Sorry, I can just hear some talking again. If everyone could go on mute, please. Refer to the code of practice, and again, I'm happy to circulate the link in the chat box about the code of practice and see what that says, and also consider applying to the Court of Protection if required. So let's now have a look at what the Court of Protection can do. So in relation to LPAs, the Court of Protection can make a declaration about the validity of an LPA, provide directions about how an LPA should be used, remove an attorney or prevent an LPA from being registered if there are significant concerns, and also make declarations about what's in P's best interest, which is often what we are involved with on a day-to-day basis. Then we can look at actually practically how disputes can be resolved and when they would end up in the Court of Protection. So it's often encouraged that if there is a dispute, then it should be settled by a meeting with the parties or through mediation. And the Court of Protection also encourages attorneys to look at alternative dispute resolution and also seek legal advice as well. Should you not be so fortunate to have resolved it yourselves and attorneys do find themselves in the Court of Protection, then the rule is that the donor estate will pay for the objector's costs. And me and Nadine are very familiar with this, having done a case recently where relatives found themselves in the Court of Protection and they were the attorneys, and then were horrified to find that the cost of mum's representation, the donor's representation in the proceedings, was to be funded from her estate. So it's an important point to raise and flag with people when dealing with LPAs, because sometimes there isn't that expectation that costs will be covered by the donor's estate, and ultimately you don't want to drain very precious funds if it can be resolved outside of court. And then, sorry, finally, if you do decide to object to the registration of an LPA as well, then that would have to go through the Court of Protection. And then I think we have flown through those now so that we can actually consider some frequently asked questions that were raised before the training was prepared. And so we've taken those questions and we've looked at them in some more detail. And I think I'll pass over to Nadine to cover off these slides, and then you'll hear from me again in a moment. Thank you.
Okay. So dealing with the first one, if we take them in turn. So will an LPA be valid abroad? The test for mental capacity differs throughout various foreign jurisdictions, and they each have their own approach in the way that they define mental capacity, as well as the various forms of representation that can be used, such as LPAs or EPAs. Sometimes they are referred to as continuing or durable powers of attorneys in other jurisdictions. The differing powers can be revoked by incapacity, marriage or divorce. So specialist advice will always need to be taken in respect of the jurisdiction in which the relevant power is to be used. So I always feel that's a bit of a lawyer response, i.e. go and seek specialist advice, but really that is the advice that we can give in respect of that, because they are different, as we've said, throughout the various foreign jurisdictions. It is always important that you seek that specialist advice, because they will be the specialist in relation to that jurisdiction. And then another question that was raised was, will an LPA made in another country be valid here? A foreign power of attorney or similar protective measure will be recognised in England and Wales under Schedule 3 of the Mental Capacity Act if it was valid under the law of the country in which the donor is habitually resident. So again, relatively straightforward answer to that question. So moving on over to the audience, and we really want to make this kind of as interactive as possible. So first questions, and this is where people may have to be brave and volunteer some answers. We're not scary people, I promise, and there is no wrong answer for us. We're always interested to hear people's views. So firstly, do GP practices have a legal responsibility to communicate with the attorney on all matters? And if no one's going to be brave, Amy might have to be my guinea pig.
No.
No, go on then, Amy.
Well, it depends on the LPA in place and what the LPA actually says, and whether the attorneys are jointly or severally responsible. And then if we think of an example, let's say we've got a nephew who has authority to access his aunt's medical records. It really would depend on what type of LPA was in place. If the nephew did not have the appropriate LPA, he wouldn't be in a position to consent to or refuse treatment on behalf of his aunt, nor could he insist on treatment that healthcare professionals felt was not in the patient's best interests. So the GP can check the type of LPA and whether or not it's property and finances or healthcare decisions, and whether or not it would be appropriate for the attorney in this position to make the decisions. It would only have been appropriate to disclose the medical records if he did have the power to make that decision.
Okay, perfect. Thank you. So question number 2 then. What happens if the GP is contacted by someone other than the attorney about the donor, such as a carer, for example? Oh, I think we've got a hand up. I mean, I'm not brilliant at Zoom. Even after all this time, I'm still not brilliant at Zoom.
Yeah, sorry, it was my hand, Nadine. Sorry, so I'm still on question 1, computing that answer. So which sort of links to question 3, because how would we know what matters we could communicate with them on unless we keep a copy of the LPA on our records? And are we legally allowed to do that?
So the answer is yes. If you do have a copy of the LPA, then you should keep that on your records. There's no reason for you not to be able to do that as the GP. And I would probably suggest that if you were seeing somebody and it seemed for some reason that you had a query over capacity, you could make those inquiries. And as we've previously said, you can actually search if there is an LPA active about somebody. Once you've found out that information, it then may be appropriate to make contact with the attorneys under that LPA and ask for consent to help to hold that on your database. And they can always say yes or no. So yes, I understand what you're saying, but I think the question raised, do GP practices have a legal responsibility to communicate with the attorney on all matters? Yes, you're right. You don't know until you know there's an LPA, and then you don't know what LPA it is until there's some investigation. But whether or not it's a legal responsibility, I suppose, is a tricky question, because you can't do this for everybody. Let's say you saw me in the practice, you know, you wouldn't necessarily ask me if I had an LPA unless you had any real concerns about my capacity, and we'll come to that at the end of today. But yeah, so it's something that you've just got to be mindful of, I would say.
Yeah, right. And I think for question 2, that's probably best answered by one of the clinical colleagues on the call today. Aaron, what would you do?
I like it, picking on people.
I don't like it. I think I would act in the patient's best interest, and if a decision was needed at the end of that conversation, then I would contact the LPA. The attorney, not the LPA. It's a piece of paper.
Yes. Yeah, I think you're right. Let's say, for example, it's somebody that was at the care home and they contacted you, then they may have some level of involvement in the donor's care to some degree anyway. But I would, again, respect duty of confidentiality and make that contact with the attorney and seek consent.
So I'm just going to summarise that, Amy. What you're suggesting is you're agreeing we collect the information in order to make a decision or to consider and then discuss our proposal with the attorney.
Yes, that's right.
Just wanted to be sure.
You still hold, if you have prior consent from the patient when they had capacity to talk to that individual who contacted you. So we had a situation where there was one LPA, an LPA in existence for one member of the family, and another member of the family had we had consent on the record, previously signed consent from the patient to say that it was okay to discuss things with them.
Sorry, you broke up. I think my internet might have just frozen on
Oh,
me.
sorry.
I'm really sorry.
So we have one situation where we had a patient whose one member of their family had was an attorney under an LPA for them, but prior to the patient's loss of capacity, they had given a written consent for us to talk to another member of the family. So would that still hold? And so that was sort of my feeling. I was thinking I would talk to the person, and then, but if a decision was to be made, I'd go to the attorney under the LPA.
Yeah, that sounds perfect to me. You can make advanced decisions when you have capacity, and as long as that's recorded clearly and you can actually point to it in the records, then I would be comfortable with that. It also acknowledges the wishes and feelings of the person, the patient, when they lose capacity as well, as to what would they have wanted. Would they want this to be discussed with X? I suppose the only difficulty you get into if the attorney disagrees with you or is unhappy with that approach, but you can then refer to the advanced decision. And I suppose it'd just be, as I said previously, about being mindful of what goes beyond the remit of the LPA, or if you think actually that advanced decision perhaps isn't valid now because there's been so much circumstantial change. So I think you're right to do it, but always be cautious and mindful that there might be somebody around the corner to say that you're doing it wrong. So keep your records accurate.
I think as well, just to add on to that, that speaking to holders of LPAs is always really important, because of course they have a role, but as Amy says, there may be other people, and as you say, if it's been documented in the records that that individual wanted another person to be spoken to, then that's entirely reasonable. And the LPA holder doesn't just take precedence over everyone else. They have a role, they have a say, but it's not the ultimate say, if you like. There are other things you need to consider at the same time. So if we move on to, I think Amy's going to take us through deprivation of liberties, and I think maybe what we could suggest, Amy, is, as we're kind of doing well with time, is maybe have a bit of a Q&A session before we move on to the case study.
Yes, that's
and
a
then
good
we
idea.
can deal with the case study then as a separate point.
Nadine and Amy, there are some questions in the chat relating to LPA. So would you like to address them now or later?
Well, what we might do in order to be fair to us is that if we're doing well for time, I might do my couple of slides on the deprivation of liberty, and we might have a short 5-minute break for people to get a cup of tea and nip to the toilet. And so Nadine and I can then look at the questions rather than being put on the spot.
That's absolutely fine.
If that's okay with everybody.
And if I can give an advance notice, they're not all questions from me. People have been direct. They've been direct messaging me, so I've been copying them into the chat for everybody. So I just wanted you to be sure I am inquisitive, but not necessarily that.
Thank you.
All right.
So this won't take 2 minutes at all either, because we're just going to touch on the deprivation of liberty and really look at what it is and who it applies to. So a deprivation of liberty, or otherwise known as a DOL, or deprivation of liberty safeguards, is a DOLS, takes place when what's called the acid test from a case called Cheshire West in the Supreme Court is met. And so the acid test is whether the person is being continually monitored and supervised, whether they are living and getting no unsupervised access to the community, and whether the person would be free to leave and live where they wanted. So that can be really broken down into 3 points to really consider, and it's never straightforward when you actually drill down to this. And you know, we often get asked, don't we, Nadine, you know, would they be free to leave? Can they just get up and walk out? And whilst they physically might not be able to do that, you know, there might maybe no restriction within the care home to allow them to do that. So it's a tricky one to get your head around, but that's the first stage of it. And then the second is, if the person is always escorted, whether by staff or family or friends, and they would be stopped from moving to another place, then the acid test is met and the person is being deprived of their liberty. So I've just read that out really so everybody can digest and process that. But when a care home or hospital has a reasonable belief that they may be depriving a person of their care and of their liberty, they make an application to the supervisory body at the local authority who would be responsible for the person's care for a standard authorisation. They may also grant themselves an urgent authorisation, which allows them to legally deprive the person of their liberty for 7 days whilst an assessment takes place. So we'll just move on now to other considerations for deprivation of liberty. So is the deprivation in the best interest of the person? If any conditions need to be met to ensure the deprivation of liberty continues to be in the person's best interest, and that any restrictions placed upon the person are as few or as restrictive as necessary. So really looking at, you know, do we have to do that? And this again has been a relevant consideration in light of COVID, because in care homes so many people haven't been able to go out and their liberty has been restricted. Restrictions can include not accessing the community, being able to exercise their faith, use of medication or equipment, not pursuing hobbies and pastimes that they usually would enjoy, and who will visit and monitor the person's placement for the duration of the deprivation of liberty. So we'll talk about this, and there may be some questions for us which we can mull over the break. But who does the deprivation of liberty safeguards apply to? Well, it applies to anybody who is 18 or over and who lacks capacity to consent to being deprived of their liberty. And the safeguards cover patients in hospital and people in care homes, but do not apply when patients are detained under the Mental Health Act. And it doesn't usually apply when thinking about GPs, as GPs are mainly dealing with patients at home and not in hospital. When a care home or hospital, yes, I think I've covered this, they make the application to the supervisory body, and yes, then they've got liberty to make an urgent authorisation if necessary, and then they will put the process in place. So we've only touched on this really because we don't know if it necessarily applies to GPs. You may say, no, I disagree. This is very relevant for us, and we've got some questions. And if so, then please do, put them in the chat box, and we can cover these off. But in terms of practical point of views and what me and Nadine often deal with, we'll be approached, by an organisation, and they will be quibbling whether or not somebody's been deprived of their liberty. And so we will look at things like, can they leave the care home? Are they restrained? Is there anything that means that they can't actually move? So are they hoisted? Have they got belts or any lap restraints? Would they be able to go and pop to the shops to get a snack or a coffee on their own? Is it just recommended that they would go with somebody, or does a member of staff have to be with them? And it's really once you've got the answers to those questions, you can start trying to assess whether or not you are depriving someone of their liberty. And unless Nadine has anything to add there, I think that's probably a good place to stop and maybe have a 10-minute break, and everybody can have a think about any questions they want to pop in the chat box, and then we can come back and deal with the questions and then move on to the case studies, if that's okay with everyone else.
That sounds lovely. Thank you very much, Nadine and Amy, for that. So if we keep ourselves logged into the meeting but mute and take videos off, and we return, 3 o'clock is 7 minutes. Is that okay, or do you want to go to 3:05, Amy and Nadine? I want to give you...
No, we'll go 7 minutes because, yes, unless anybody's got a very long walk to the kettle.
Okay, so let's resume at 3 o'clock then.
Yeah,
okay.
We'll see you then.
Thank you, Pete.
Thank you.
Wow, it was brought to my attention first thing this morning. It's because I filled them all up, haven't I? When she wasn't here. Yeah. That was the thing. Well, what do we do?
manager of the care home the patient was living in. If we had acted on this, would we have been liable? So I think it's important to note that sometimes LPAs are made by individuals on their own and with the support of relatives, but actually solicitors are often instructed, and there's private client teams within local high street solicitors. This is their bread and butter, to actually apply for a lasting power of attorney on somebody's behalf. So I think it's important to say that check whether or not a solicitor had tried to register it with the OPG, because they would have some legal kind of duty of care and consideration as to whether or not they have followed the guidance correctly when registering that. So see if there was legal advice taken, or if you're aware of that, then maybe it's the solicitor's problem. But ultimately, the responsibility is with the Office of Public Guardian, because they're responsible for approving these. And I know plenty that come back because the forms have been filled in incorrectly. And when you complete an LPA as well, there is a whole host of guidance as to who's a suitable certificate provider, who's a suitable attorney, and there's an obligation on the people entering into it to actually make sure that they're the correct person when they are giving that declaration as well. So I think the short answer is that ultimately it's the Office of Public Guardian's fault because they passed it through, but that may be because there's been a false declaration made or a lack of understanding by the parties when creating that LPA as well. But it's for the OPG to sort. And if it's got a stamp on it and it's been registered, then would you be liable? Well, you're acting on a valid LPA. I suppose if that information came to light that they in fact were the care home manager, then I would say that it would probably be a good idea for you to contact the OPG and raise that concern. Nadine, do you want to do the next one?
So the question was, is there an OPG stamp? And then even if documenting, what happens if you do not believe that the attorney is acting in the best interest? In relation to the OPG stamp, on that example LPA that we saw a little while ago, there was a stamp on there. So yes, they do have a stamp. In relation to if you do not believe that the attorney is acting in best interest, both Amy and I have been involved in cases where there's been some concerns about an attorney and not acting in the individual's best interest. And really, it's a matter of raising it with the OPG. The OPG will have lots of conversations with people about whether or not an attorney is acting in someone's best interest. So if you have concerns that an individual isn't acting in someone's best interest, then it's always worth raising that. And it should be raised because it's important for the OPG to know what attorneys are doing under LPAs and whether they need to take further action. In actual fact, in one of the cases that I was involved with a little while ago, as part of the concerns, the OPG did take that to the Court of Protection because they said that the attorney wasn't acting in an individual's best interest. Amy, do you want to take the next one?
Yes, so if you have a doubt about it being a valid LPA, is it reasonable to ask the attorney to provide evidence from the OPG, or is it practice responsibility to verify? Well, I would say that if I was the GP, I'd be contacting the OPG directly rather than looking for evidence from the attorney. And the reason for that is, whilst an LPA may have been registered, it may have then subsequently been discharged. Let's say you're dealing with a dodgy attorney and the OPG's taken it to the Court of Protection, it's discharged and he's got some old paperwork, then you don't really want to be trying to verify documents from the attorney. So I would say yes, go to the OPG directly and try and get that verification because that will be accurate. Nadine?
So then the next question that we had was, if someone has an enduring power of attorney, does this still count? Should they now be making a lasting power of attorney? So enduring power of attorneys are still valid, but they can no longer be made. Interestingly, with enduring powers of attorney, they were valid as soon as they were made, and you didn't need to register them until the individual lost capacity. Obviously now with lasting power of attorney, they have to be registered with the OPG in order for them to be valid. So there's a bit more of a scrutiny in relation to LPAs than I suppose in relation to enduring power of attorneys. But certainly if someone still has an enduring power of attorney, they are still valid. They're just sort of being phased out because you can no longer make one. So eventually we will get rid of them all and they will all be LPAs. But at the moment, there are still some valid enduring power of attorneys. And then finally, Amy, if you take the last question.
I don't think that there's a legal response to that. I think if it was me and I wanted to get a very quick response, I'd probably fire off the email and then ring them at the same time. And hopefully you've got an answer either on the phone or an email pings on while you're still on hold. I'm sure with experience or with practice, somebody on the line may be able to say, oh gosh, I checked one and it took forever. I often think as well that if you send the email, providing it's not urgent, and then come back to it, then as we know that there is that guarantee that for an urgent check, it will be seen within an hour.
And have you experience of that, Amy or Nadine? Have you had responses within the hour?
Well, with me personally, it's usually our clients that do that just to keep the costs down because it's very expensive for them to have a solicitor on hold. So we would say make the inquiry yourself and let us know the response.
So I think that's probably all the questions for the time being, but hopefully at the end of the case study, if things come out the woodwork whilst you're thinking about the case study, I'm sure we've got probably some time at the end to deal with any final questions. So really, we want you to now kind of put your thinking hats on. We've come up with a bit of a scenario in respect of a case study, and we would really like it to be as interactive as possible because everyone has slightly different ways of working. This case study we've sort of pulled together from a couple of cases that both Amy and I were involved with quite recently, just so that you can see the sort of things that might happen in relation to a case involving an LPA and why you might get involved with one. So the main characters for the case study are as follows. So we've got Alfie, Bertie and Charlie, 3 brothers who are aged over the age of 18. We've got David, who is the son of Charlie, and then Mrs. Andrews, who is the mother of Alfie, Bertie and Charlie. You'll have seen I'm not very creative with my names. So if we have a look at the first part of the case study. So Mrs. Andrews attended a solicitor's firm 10 years ago and asked to make a lasting power of attorney so that her sons could make decisions on her behalf. At the time, although she went to the solicitor's firm, she asked him not to register it, as she still wanted to think about how she wanted her sons to make decisions on her behalf. The solicitor wrote on the LPA that the sons could make decisions on their own and together. And at the time that we're thinking about this first bit of the scenario, she has capacity. So the 3 questions really to have a think about for the first bit is whether the LPA would be valid and can you rely on it? Secondly, are you able to tell the type of LPA from the information that's available? And thirdly, how can the sons make decisions? So jointly or jointly and severally. And obviously Amy went through the differences. So I don't know if you want to have a couple of minutes to think about it or if we want to just talk it through as a group. It's probably worth just talking it through as a group. As I say, there are no wrong answers. It's all about a discussion. So please don't be afraid to put your thoughts forward. And if not, then I suppose me and Amy will answer it between us. But if we look at the first question, so question number A, would this LPA be valid and is it able to be relied upon? Does anyone want to be brave?
It was never registered at the time, and we don't know whether the sons were over 18 at the time because it was 10 years ago and you haven't told us how old the sons are.
Of course we do. We're lawyers, we always leave little bits of information out at times. So yes,
Were they over 18 10 years ago?
I suppose, yes, they were. So let's say they were over the age of 18 10 years ago.
We don't know if it's been registered since.
No.
It wasn't valid at the time because it wasn't registered, but she may have gone back to them and registered it since.
Yeah.
10 years ago, would it have been an enduring power of attorney or rather a lasting power of attorney? I can't remember when the rules changed.
It quite possibly would have been, yes. But yes, it would have been.
Amy's
issue
trying
with
to find out for you, I think. Amy's Googling there. So if it's been registered with the Office of Guardians, we'll consider it valid if it's not a stamp.
People can come in.
So yes, so looking at the questions that we've got, I do apologise, I've got an alarm going off. Sorry, I thought it sounded like I've got an alarm going on somewhere in this house. So would this LPA be valid and is it able to be relied upon? Based on the facts of that first bit of the scenario, it hasn't been registered. If it related to health and welfare, then at the time as well, she has capacity. So don't forget as well, as you'll know, for LPAs for health and welfare, the individual will need to have lack capacity. Again, you're not able to tell the type of LPA from the information that's available. It's not clear whether it's health or welfare or financial decisions. And then how can the sons make the decisions jointly or jointly and severally? So if we just go back, it says that the solicitor wrote on the LPA that the sons can make decisions on their own and together. So that would be jointly and then jointly and severally, sorry, rather than jointly.
2007, October 2007. I remember rushing my grandmother's through. So I thought it was 2007. I thought, oh, now I best have a Google and check. Don't want to embarrass myself.
And in terms of, are most LPAs done jointly nowadays where it's practical? Would legal advisors advise people to do jointly, or is it really?
I personally would say it's really up to the individual. Amy and I had a case where 3 individuals were appointed to act jointly, and it was a bit of a nightmare because 2 of them agreed with the decision and 1 of them disagreed with the decision, and we ended up in the Court of Protection with it. I think it really is personal preference as to how that person wants to deal with their affairs, and really it's a personal decision for them. But certainly we don't tend to advise on individuals making an LPA. We tend to much more deal with organisations, so GP practices, NHS trusts, things like that. I don't know whether Amy's got anything to add.
Just as well, it depends on the group of people that are the attorneys. You know, if it was to be, you know, if it is just relatives, so let's say it's your 2 sons and a daughter, then you may want to keep it jointly. But as things change and life moves on, you know, people have family arguments and fall out, and it makes things very difficult. But yes, I agree completely with what Nadine says. There isn't any rhyme or reason as to why people do it in a particular way, and it is totally on a case-by-case basis.
Amy, do you want to take the next bit of the case study?
I do, yes. I will talk you through that now. So we've fast forwarded 10 years. Is this the right one, Nadine? Yep. Fast forward 10 years and Mrs. Andrew lives on her own and does not receive any support from her 2 of her sons, Alfie and Bertie. Charlie and his son David do go to see Mrs. Andrews on a weekly basis and support her with daily living. 3 years ago, Mrs. Andrews decided to speak to the solicitors about changing the LPA for health and welfare. And And then you go to see Mrs. Andrews as she's complaining of a cough and a sore throat. Due to her diagnosis of dementia, you have in the past considered that Mrs. Andrews does not have capacity to make decisions. When you arrive, you note that there is a piece of paper which is titled Lasting Power of Attorney. You are also aware from your records that Mrs. Andrews did not receive her COVID vaccine. And then we've got the kind of document here. So lasting power of attorney for health and welfare, registered 20th of January 2020, entitles Mr. Alfie Andrews, Mr. Bertie Andrews and Mr. Charlie Andrews to make decisions in respect of health and welfare jointly. It has been signed as appropriate and has an OPG stamp on it. So the questions are, is it a valid LPA and is it now engaged? And secondly, how are the sons entitled to act and what does it mean if the sons do not agree on the decision?
Do we know whether she had dementia on the 20th of January 2020? Because if she did, she wouldn't have been able to make the decision. Who was the person that said she was able to make the decision at that point? Who was the professional?
Well, I think these are all questions that you would raise, wouldn't you, into? So the purpose of the case study is just to get people to have that discussion and to think about what they would need to consider. So we don't have the answers. It's an example, but I'm not disagreeing with what you're suggesting.
Potentially, it's not a valid LPA.
Yeah. And so what would you do then? You'd call the OPG and you'd say, wait a minute, can I just check about this? Yeah. Or, you'd consult the medical records and you'd see if there is a capacity assessment or if there's any concerns about dementia in that time period. So they aren't necessarily straightforward. There's always lots of digging, and that's why it's really good to kind of have these conversations, because what you're thinking of, perhaps somebody wouldn't have thought of and would have just waved it through. So it's really good contribution. Has anybody else got any thoughts?
Amy, if we didn't have chance or opportunity and time in general practice to do all these checks, so took documents on their face value, what would be the repercussions to the practice if those documents turned out not to be appropriate or the timing was wrong?
Well, it depends on the action, really, and so can you give me an example of, So,
for example, if with this case study, if we hadn't gone back and checked the dates that we mentioned dementia, or we've done a quick glance and just not quite captured, the date correctly. So it might have said 2020, but maybe it was a month before that. And we've just not quite clocked that in our quick scan of the records. But then it later transpires that we felt that she would not have had capacity, but we've made action in accordance with the LPA. Would the practice then be liable?
Well, again, when you're talking about liable, it suggests that there's been some kind of clinical negligence, or, I don't think the decision you're making is going to result in anybody's death or any injury. No. I mean, it could. I mean, you could take that, the vaccination example, that you went ahead, and this is getting quite elaborate now, but let's say you went ahead and you shouldn't have, and had the vaccine, and she died as a result of a complication of the vaccine, and then it worked out that it wasn't actually a valid vaccine, then there'd be an inquest, there'd be an investigation, and the inquest would look into the interested parties and the role that they played in that, and so you may be called and said, well, why did you go ahead with that on the basis it wasn't a valid LPA? And you could say, well, it had a stamp on it and it was dated, and therefore we were of the view that it was valid. It's not an easy question to answer. It's very based on the circumstances and what would happen.
I don't think that's elaborate, Amy. That happens every day in general practice, so that's actually quite,
yeah. And you often find that you're dragged into things, but it's at that point then you would contact the solicitors and say, these are the reasons why we did take those actions. Here are our records demonstrating that we recorded our decision to do this on the basis that we had seen a valid LPA. So back to those exclamation marks that Nadine referred to about record keeping, it's so very valid. And And it's just actually engaging with the documentation and questioning things. And, you know, I know that you have time pressures, but if you are just querying things, and the benefit of this training today is hopefully people will go away and be a bit more alive to potential things that could happen, and then we've done our job. Where it ends is another matter, but it's just that having that awareness really that's key. So let me just, sorry, I'm on a different screen. So the questions is it a valid LPA and is it now engaged? So the answer is yes. And again, take this with a pinch of salt, because what we haven't done is kind of make a dummy LPA rubber stamp. We've just given you the wording, but based on the wording we have there, yes, as it is registered, it's validated and signed appropriately, and it is engaged as Mrs. Andrews lacks capacity to make decisions. Again, we've heard that she lacks capacity, but if you had any concerns about that capacity status, then we would ask you to take further inquiries about that. And then B, how are the sons entitled to act, and what does this mean if the sons do not agree? Well, as they've been asked to be appointed jointly, then if they're unable to reach a decision together, then a decision cannot be made, and they should start to think about a court of protection if a decision can't be reached. Also, in addition to that, you know, they may want to look at mediation, alternative dispute resolution, to see if they can reach a decision on the basis that it's probably going to come out of Mrs. Andrews' pocket if they start arguing about whether or not it should be given.
My little yellow hand up. Simple. So my actually had to have an answer question. If they are doing it separately and they don't agree, what happens then? So if they've got one person and they're making a decision, obviously they can make it on their own. What happens when you've got opposite decisions from two of them?
Nadine, what I was going to say is that yes, if it's jointly and severally, then they can act in individuals as well as jointly. So that is permitted. It may be that there's a big whole family argument at home if somebody presses ahead. So practically, obviously, they do need to be consulting each other. But it may just mean that actually they don't all need to consent for it to go ahead. So you could say, I don't know, you've got 3 siblings and they say, yeah, I'm fine with what you've said, or somebody says, well, I'm not really bothered, and then the other one presses ahead. So practically it may cause problems, but legally it's not a bar. Whereas we found, sorry, go on.
Sorry, in terms of being the GP, if you've got one person saying, I want you to do this, and another person saying, I don't want you to do this, and then both last power of attorneys with the right to make that decision, where does it leave us?
Calling the OPG, I think, and saying that we're in a bit of a sticky position. We've got conflicting views. It's jointly and severally. What's your advice? And it may be then that they open that investigation and say, oh, given these circumstances, it's not appropriate to act under the LPA on this circumstance. We'll have to take it to the Court of Protection.
Karen, just to note, you've developed a very big echo on your line that it's very difficult to hear you. So I don't know if there's something else happening in the room.
I was going to say, I'm glad Amy picked that question up, because you sounded a bit like a Dalek to me. So well done, Amy, for managing to hear that question. So if we move on, I'm sure Amy sort of foreshadowed what you might think is coming. But next part of the scenario is that you speak to Charlie and David about Mrs. Andrews. So Charlie being one of the sons and David being the grandson, about Mrs. Andrews and the fact that she's not had her COVID vaccine. Both Charlie and David were unaware that she hadn't received the vaccine. You asked Charlie about Alfie and Bertie's views, and he says that they do not agree with the vaccine and do not think that they would want her to have it. David, a keen science student, expresses strong views that Mrs. Andrews should have the vaccine. And Charlie isn't really sure, as Mrs. Andrews does not go into the community. So he's kind of unsure about the status of the vaccine and whether or not Mrs. Andrews should have it. So I suppose the question we've got for you at the moment is, well, what do you do with that information? If you were confronted with that scenario, knowing about the LPA and assuming that the LPA is valid, what would you do? Anyone going to be brave? So if we look through it, oh, go on.
I suppose you could make a best interest decision as a clinician, or you could try and talk to the two that are anti-vax and see if you can persuade them.
Yes.
Or a mixture of both.
Yeah, and in actual fact, I'd move the slide on before you'd finish, but that's exactly right. So first of all, check the LPA. We've kind of been going on about it, and as I say, we've assumed that it's valid for this situation. But again, check the LPA. It should always be a point when you consider. Speak to Alfie and Bertie and obtain their views. As they've all got to act jointly under the LPA, it is important to get their views and for you to almost get their views on your own, not through second-hand information. Consider the issues of best interest and also what would be in Mrs. Andrews' best interest. So the COVID vaccine, both, again, Amy and I, and actually I was in court yesterday all day on a case about a COVID vaccine, considering what would be in somebody's best interests is really difficult, but it should be considered. Consider Mrs. Andrews' wishes and feelings and any previous vaccination history or advanced decision. So have you got access to her medical records to go back through? Was she receiving the flu vaccine, for example? Had she got any wishes and feelings about particular vaccines when she did have capacity? And also speak to Charlie and David. Just remembering the fact that David's under the age of 18, he should still be consulted though. He has got views and he's entitled to those views, but it's just remembering that actually he's under the age of 18. So really it's Charlie, Alfie and Bertie that you'd really need to be considering because they're the ones under the LPA, they're the attorneys. So moving on again, Amy?
Yes. So again, it's building on that. You call Alfie and Bertie separately and both individuals are adamant that they do not want Mrs. Andrews to have the vaccine. You then call Charlie and he's been thinking and does consider that Mrs. Andrews should have the vaccine. Now what do? And are you able to favour one person over the other? And can you take David's views into account? Any views?
Well, is this where we might have to consider it going to the OPG? Because we couldn't really override it with the best interest decision, I would have thought.
Yeah, that's exactly right. So on my next slide is what do? Convene a best interest meeting to see if you can resolve anything. At that best interest meeting, it sounds like all that will happen is it will formally be recorded what the attorney's views are, and then that we won't be able to come to an agreement. So as there's still a dispute, then need to consider court of protection. Are you able to favour one person over the other? No, not able to favour one over the other, as holds the LPA jointly. You can add David's views, but the three attorneys are Alfie, Bertie and David. So that's exactly right. And also, just before moving on to that, I was going to just touch on, Nadine, that we're seeing now more than ever GP practices bringing their own applications to court. Now, usually it's dependent on funding, and usually there is some funding available. So, you've got P who's maybe in a care home, there may be some local authority funding or some CCG funding. And in those circumstances, it may be that those organisations would take the application to court about a decision on a COVID vaccine. But more recently, as GP practices are actually administering the vaccine, there's been pressure on them to bring the application to court themselves. And we would say if you're in that scenario, pick up the phone and give us a call, and we'd be happy to help you through that, whether that's just some, you know, generic advice, or whether actually helping you fill out the forms and taking you through that step by step, because it can become very complicated, because it's not just a case of applying to the Court of Protection and then that's your job done. As an applicant, it's a very onerous responsibility. You need to notify lots of different people who are involved in PEAS care, and you also have to set out care and treatment plans, so setting out why it's in the best interest to deliver the vaccine, recording and acknowledging people's views as to why it isn't, putting a care and treatment plan in place. Let's say P needed to be restrained in order to have the vaccine, then all these options need to be available for the judge to make a decision. It may be that you don't think restraining to give the vaccine suitable, but unless that option is available for the court to decide on, you may find that you get your order saying yes, you can vaccinate, you get off to CP, and he's not engaging, and therefore in order to cover off the restraint point, you've then got to go back to court. So I know that that's a massive sidetrack, Nadine, but I just thought it was an important point to flag.
Yeah, it is really important. And actually the case that I was on yesterday, before the Court of Protection, was a GP practice taking that step precisely, that they had taken it to court. It was for an individual in a care home, and sorry, not a care home, it was a supported living placement, sorry, and the GP was administering the vaccine. In those circumstances, the GP practice considered it was necessary to take it to the Court of Protection, and we supported them through with that application, and was successful in getting an order which said that the GP practice could vaccinate the individual against the wishes of the individual's parents. So just kind of practical example. So going back to our scenario, if you get to the point where you've clearly got the dispute, so you've got a dispute about what is considered in someone's best interests, so it may be that the GP practice thinks that there should be the vaccination, and then the sons can't agree on whether or not they consider they should vaccinate. Obviously, we've got two that are opposing the vaccination, and Charlie, who isn't really sure. On what basis, again, would you be making an application to the court, and what evidence would you need to think about, and what would you need to provide to court? So this really, I know this is kind of going outside of the scope of an LPA training, but it's just to get you to start to think about where Court of Protection is necessary, the sorts of things that you might need to consider, and the sort of documents, because when me and Amy have run these training sessions in the past, a lot of the comments whenever we do training sessions about the Court of Protection is, oh wow, I didn't quite realise we needed that much information, or that specific information to go to the court. So we always like to add it into scenarios just to get people thinking. So is there anything that you can think of that you would probably need in relation to this potential application, that you would need in order for evidence or documents to take it to the court?
Do we have any members on the call that have not spoken so far that would like to contribute? Elizabeth, I saw you take your mic off, so do you want to...
No, I'm trying not to answer it this time. I assume you'd need information about her past health, about previous vaccinations. Would you need to provide anything about her dementia, about the actual LPA as well, or would that already, you'd have all that, because you wouldn't necessarily have a copy of the LPA to provide, would you? Or can you acquire one from the office of OPG?
Yeah, so in relation to the LPA, and Amy, feel free to jump in, but normally when you check whether one's registered, there is a document that we always include with applications, because yes, you would need to have a copy of the LPA, or at least some form of document which shows that it's valid and registered, and who can act and whether it can act jointly or jointly and severally. And again, you get that document if you do check whether an LPA is available and valid.
Sorry.
No, I was just going to say, and secondly, in relation to capacity, then yes, you would also need what we call a COP3, which is a specific quarter protection form available on Google. But again, it has a capacity assessment, because the quarter protection has only got jurisdiction if somebody lacks capacity. So one of the first things that the court will always check is whether or not there is a completed COP3 form, and it's been completed in relation to the specific decision that needs to be taken, just so that you can evidence a lack of capacity.
Would you also need to provide any information about COVID vaccinations, about levels in the community, about the fact that X many people go in to see this lady because she's got carers and various other things which would increase her vulnerability, you know, all that sort of thing. Line science, sort of.
Yeah, the number of people in the home that it might affect, if you know, that may bring risk to her.
Exactly. And thinking about that a bit more, it's kind of thinking about what are the risks as well if she doesn't have the vaccine. So, you know, there's talk about kind of COVID passports and that sort of thing. So accessing the community, she might not be able to do everything that she'd normally do. The judge really wants to hear about the individual. So as much of that information, now I appreciate as a GP practice, you may not have that information. So what would probably happen is at the first hearing, the judge would probably then direct, if she was in a care home or whatever sort of placement, or even if she was at home, they would direct some form of extra evidence, so that they can set out kind of what her lifestyle was like at home, so they can work out what impact it would have. But certainly you'd need all the information about the vaccine and kind of what the rates are in the local area as well. At the hearing yesterday, the judge was very interested to know whether or not that particular location was above or below the national average in terms of rates of infection as well, so that he could consider that as part of his consideration for whether or not this individual should have the COVID vaccine. So if we have a look at what we've sort of pulled together, and we've kind of covered all of these, and as Amy said, we're always willing to help with applications and do accept instructions on behalf of GP practices. So if you do ever feel that actually this is starting to become very lawyer driven, then please do pick up the phone to us. You know, we're more than happy to help. But you would be considering bringing an application as there is dispute as to what is considered to be in her best interest. And it's likely that it would be the GP practice, because you would be the one administering the vaccine. You would be the one that would be completing the care for that individual. In terms of evidence, then you would probably need to include the following: copies of medical records, which again may include past wishes and feelings, previous vaccination examples, which is most likely to be flu vaccine. Some evidence setting out wishes and feelings of the sons, and so that you can show that there is a dispute between everyone. It might just be a paragraph in a witness statement, for example, saying that, well, I spoke to Alfie and Bertie on X date and they had this view. I spoke to Charlie on X date and he had a different view. And again, those conversations would probably be documented in the medical records as well. So your records would back up what you're saying in your witness statement. You'd need a copy of the LPA or the document that you received, checking whether or not there's an LPA in place. As we said, a COP3 form setting out evidence in relation to capacity. And the courts like to see a capacity, it could be on the same form, but it's a capacity assessment in relation to, firstly, conducting proceedings. So can the individual take part in legal proceedings? Normally that's no, and there's a lack of capacity. And then secondly, whether there's capacity in relation to the specific decision, i.e. whether or not she has capacity to make a decision about the COVID vaccine. So both of those would normally be covered off in the COP3, which you put in with your application. And as we've said, a witness statement, normally from the GP, if it was the GP practice taking the application forward, setting out why the vaccine was necessary and kind of the relevant background, and also discussing the vaccine more generally. And then there's some very boring application documents, which may be boring, but they are necessary, that have to include it, being a COP1, COP1B, COP2. So there are various forms which you would need to complete and sign and send in with the application. So that's really a very quick whistle-stop tour of kind of how an LPA might get dragged into a best interest dispute, and what sort of things that you would be considering as part of questions about an LPA, and kind of how that then turns into maybe getting the Court of Protection or the Office of Public Guardians involved. I'm wrong, but we've probably got some time if anyone has got any further questions for anyone. I'm slightly concerned. I've just had a think about saying my internet connection is unstable. So I'm hoping you can still hear me.